Good morning. May it please the court. I'm Janet Pumphrey for the defendant, Juan Mejia. This is the All Mejia Day. First,
Are they related?
I doubt it. I don't know. I don't think that was not the same county, not a Hampton case. The note. The note was excluded, and it was a bitterly contested battle to exclude it. Pre-trial, the Commonwealth moved to get the note in. The defense moved to keep it out. After argument, pre-trial argument, the note was excluded. The court expressly found that the note was ambiguous. The jury might give it too much weight, even on the issue of Mr. Mejia's guilt. And finally, the second time with the Commonwealth's renewal of the motion to in limine, the court found that it was impossible to determine when the note was written. Then on the second day of jury deliberations, the jury sent out a question, is it possible to have the note translated? The court immediately called the jury into the courtroom and said, long explanation, that note is one of the things you should not have before you. The foreman reported that he believed that 4 jurors got to look at the note.
No, it was in Spanish.
It was in Spanish.
And the judge spoke to each juror individually.
Right.
And concluded that no one spoke Spanish. And so they
That's
didn't
right.
know what the substance of the note was, and that they were not unduly influenced by the note.
That's right. I believe the process by which the judge questioned the jurors was all exactly right. I mean, he brought each juror in and individually voir dired them. But the essential question here is, was that adequate given the exact circumstances of that this seemed to be a confession. In other contexts, most cases find that this kind of extraneous information is not significant. And there are cases which are in my brief, another individual's arrest and a recovered gun, a defendant's pending charges, exhibits that should not have been before the jury. But in other situations, it's highly prejudicial, as it is here, just given the nature of what it is. Defendant's criminal record for a newspaper, that was reversible. Unauthorized taking of view, that was reversible. And co-defendant's flight.
But don't they have to understand what those items are in order to make them prejudicial?
Well, I would suggest that this is even, the way it played out, it's even worse than had they had a translation of the note, because the note was ambiguous and there's no telling when it was written. But the way it played out, the jury had to think that it was a confession because such a big deal was made of it.
And also, I mean, I assume, is it just that it was a big deal? Or I thought there was some argument that there was some way in which it was brought to the jury's attention during trial.
During trial, absolutely. They were guessing at what it meant. I mean, the entire jury knew. The foreman may have said only 4 jurors actually tried to read it. Those were probably the 4 jurors who maybe spoke a little Spanish. Nobody was actually able to translate it, they said. But they were deliberating over, they wanted the note translated, they wanted to know what it said. They thought it was a part of the case. So I think
apart from what the judge said, what was it at trial that they understood about this note? I think you're arguing that they assumed and could have drawn from this, or inferred, even if inaccurately, that it was some kind of a confession. Some kind of a confession.
I think that the one juror, the juror number 8, basically was the one that said, I would have to give it some consideration. I can't ignore it. And I think they must have thought it was a confession.
But based on what at trial?
Based on what at trial?
Well, not really anything at trial, except perhaps the prosecutors referring to it.
What did the prosecutors say?
The prosecutor questioned his witness about it. He knew that the note had been excluded. He intentionally questioned his witness about it, and there was an objection, of course. The Commonwealth, in their brief, says that those intentional references to the note were excused, basically, on 2 grounds. First, they were in anticipation that the motion would be renewed, and secondly, because the judge had found that the note was too ambiguous. But those are really insubstantial excuses, I would say. The first excuse, anticipation of the renewed motion to admit the note. Well, the note had been excluded. Period. You don't go there. And the second excuse, that the judge had found the note to be ambiguous, it just misses the point. The note had been excluded. End of story.
The note in part had been excluded because they didn't know when it was made. And
Right.
it wasn't the prosecutor trying to elicit because it was found where it was found.
Because it was
That
found
they
in
could
the closet.
determine,
Right, right.
From its location and its condition when
Right.
it might have been.
I think that the jury would have to have thought it was a confession, because what else would have been such a big deal? The judge really tried to do the right thing, but I think that what ended up happening, the way it played out, is that the judge's remarks in themselves planted the idea in the jury's mind that this was a confession they shouldn't have.
Well, are you arguing that what they heard about the note at trial was prejudicial?
They heard very little about the note at trial, but they knew it existed, and they knew that they had it, and it was suddenly a very big deal that they shouldn't have it. I think it's almost worse than had it been translated for them, because
Well,
it was ambiguous.
What did the judge say to them during voir dire on this?
He asked a whole series of questions. The main question was, let's see.
I mean, was there something along the lines of you're not to speculate on what?
Exactly. And absolutely. The
well,
judge, when they sent it, go ahead.
Shouldn't we assume they followed that instruction?
Well, he absolutely sent them back with that kind of instruction. You should not speculate. He gave in the judge's final instructions, he talked about that again. You shouldn't speculate on evidence that was not before you, or was not intended to be before you. But I don't think there's any way they could have ignored this, elephant in the room, which had to have had this incredible significance. And I think
Is there any evidence that the jury knew that it was that he wrote it?
They're actually, they didn't get there. I mean, because it was not going to be admitted, there really was no evidence that he actually did the writing of it, because it wasn't coming in. But I think that had to be the inference, was that it's such a big deal, it had to be, and he lived there.
Say it's such a big deal during the course of trial. I assume
No,
it was
I'm
not
talking
made a
about
big deal.
after, when they were in deliberations, is when it became a
it was
big
not
deal.
It was not only this document which mistakenly went to the jury.
That's right.
But the whole file of documents which were for ID only.
ID only. But there was nothing else really in there. There was the DNA report, there was a witness's criminal record, and the jury questionnaires, I think nothing else of any kind of significance except for
DNA report where his DNA was found
Right,
would be of significance, but so why do you say that his concern about it would be understood by the jury to be focused only on this note as opposed to the entirety of the ID documents?
I just don't think the other ID documents really are not particularly relevant. I mean, there was plenty of testimony on DNA, so that I think that seeing the DNA results first are hard to interpret if you don't know what you're looking for, and the other things were really not particularly relevant. But the note was highly relevant and incredibly inculpatory, I think. And as I said, I think the judge tried to do it right.
Well, excuse me.
Yeah.
And you said in highly inculpatory?
I think it could be interpreted in it sounds like a confession.
If they spoke Spanish and could interpret it.
That's right. But they were trying to translate it when they asked for a translation. So and I don't think you really know how far they got in trying to translate it.
Now, what do you say is the standard? You appear to differ with your sister as to what the appropriate standard is for our review.
Yeah, for your review, I think it's prejudicial error. There were objections at the yin-yang, and it's a preserved error. The Commonwealth's burden
So we should treat it as if there was the mistaken admission into evidence
Exactly.
of a Spanish language document.
Of a Spanish language document, exactly. And it was extraneous information that the jury received, and the Commonwealth's burden would be to prove that it was not prejudicial, and they didn't meet that burden.
And now the judge found they did.
Right.
And we're reviewing the judge.
Right.
And she
Exactly.
says it's an abuse. She says that's a discretionary call.
Well, it's really there was a motion for mistrial. There were a number of motions for mistrials, and those were all denied.
Okay. And so is the standard abuse of discretion, or is the standard
Well, I
something
think for
different?
denial of a mistrial, I think it is abuse of discretion. I mean,
So it's not prejudicial error?
But I think it is prejudicial error because it's an error in getting the, extraneous information to the jury and letting it go.
But don't we look to see what the judge did vis-a-vis
Exactly.
the jury in conjunction with this document? And didn't the judge in effect give a curative instruction?
He did. And
he said to
the
them,
judge did everything right.
Yeah, but if he said you have to disregard that, don't we look to see if the judge committed error and
Well, I think the error is in not realizing the enormous significance of this note. I think that this is not just like the other examples of insignificant extraneous information getting to a jury.
But I mean, sometimes things a lot more explicit than this note occur during the course of a trial. They come out, and there's an objection. A judge gives a curative instruction, and the jury is presumed to follow the judge's
That's
instruction.
right. I mean, there's certainly that presumption.
Why wouldn't that apply here?
I think if you look at what juror number 8 said, it seems that that's exactly probably what most jurors, they have now the
Well,
thought.
that's because they were given the document.
Right, they were given the document.
And then it was taken away with the instruction to disregard it.
That's right.
So why
That's right.
why isn't that enough?
I just don't think it's enough when there was not much evidence of guilt in this case, and this is what appears to be a confession. And as I said, I think it's worse to not have had it translated than to have it translated, because it could, it really could have said much worse than it did. Again, I think the judge's remarks he tried to do everything exactly right, but I think the remarks that he made planted these issues in the jury's minds, that this is so significant, this is a serious matter, you should not have received this. It's a huge, and it's basically asking the jury to ignore this elephant that's in the room that is just gigantic.
But, I mean, if he had been more soft-spoken about it, wouldn't you be arguing that he was not emphatic enough to tell the jury that they should disregard it?
Probably. But I do think he really, by bringing in all the jurors and by daring the jurors, he tried to do the right thing. But I would just suggest that
You're just saying the only right thing he could have done was declare a mistrial.
mistrial. That's right. It was just too big a mistake. The conduct evidence. The defendant was taken to the hospital on December the 10th. As you remember, he was at the scene. He was acting very strangely. The police arrived. They pick him up. They put him in the cruiser. He's sitting in the back of the cruiser, in his delusional state, eating food off of an imaginary plate and sopping up the food with imaginary bread. So they took him to the hospital. He was psychotic. He was delusional. The bodies were discovered 2 days later, on December the 12th. The officers went to the hospital to question the defendant that evening, sometime after 8 p.m.
I just stop. You're using psychotic and delusional in the source of that.
The source of that, delusional. He was referred to as delusional, and I think that may have been one of the officers.
It wasn't medical testimony.
It was not medical testimony. There was no medical
This is
testimony.
an assumption or an
That's
inference
right.
based solely on what?
On the lay
person-
testimony, absolutely. And it may have also been the word psychotic. Those two words are definitely in his medical records, which I'll get to because
But were not.
but were not
introduced at
admitted.
trial.
There was no medical testimony at
There's
trial
a decision made not to do that.
by trial counsel.
Correct.
The officers went to the hospital on December 12th, the day the bodies were found, to question the defendant. At some point before they went to the hospital, a determination had been made that there was probable cause to arrest the defendant, and an arrest warrant was issued while they were there at the hospital questioning him. The officer admitted that he knew they were seeking a warrant, and he knew that he could have arrested the defendant as soon as he got to the hospital. Yet they chose to take the defendant to the conference room before they arrested him. I would suggest for the sole purposes of evading Miranda. The motion judge allowed in the conduct evidence on the sole ground that the defendant was not in custody at the time of the questioning. That finding was erroneous. In determining whether a defendant is in custody for purposes of Miranda, the court looks at 4 factors. First, the location of the questioning. Here, he was brought into the hospital conference room by the officers. He was surrounded by police officers, and he was eventually wrestled to the ground by police officers. Secondly, whether the investigation had begun to focus on him as a suspect. And not only had it begun to focus on him as a suspect, he was about to be arrested. He had not been arrested yet. Third, whether the interrogation itself was aggressive or informal. It didn't actually get to that because he started with his conduct behavior at the very beginning of the.
That's just one question, a statement, a question. It was, in any other context, you might say innocuous.
The conduct evidence.
No, the statement that produced the conduct. There was,
the statement. The statement was just, we want to talk to you about what happened on Pearl Street. That's right.
Right, that was the statement.
That was
and
the
then
statement.
It produced that.
And it induced that conduct. That's right.
And would that be enough to be interrogation?
I think it would be because it certainly was interpreted by him as interrogation, I think. I mean, that induced the bizarre conduct of rocking back and forth and banging his head and trying to swallow his fist and not speaking. And finally, four, is whether the suspect was free to leave the interview. And he was certainly not free to leave because he was wrestled to the ground by the officers and he was immediately arrested.
Well, he was wrestled to the ground by also, I gather, because he was becoming a
acting
danger
out.
to himself.
That's right. I mean, they basically said we made the decision to take him down. And then a nurse was called and he was given a shot.
That was after the fact, though.
It was after the conduct. That's right. That's right. There's no doubt that Mr. Mejia was in custody for purposes of Miranda. The references to his silence cannot be used against him to infer guilt. The Commonwealth cites the Grenadier case for the proposition that Doyle versus Ohio applies only to a defendant's post-Miranda conduct or silence. And here, the defendant wasn't Mirandized. He should have been given the Miranda warnings. But interesting, the lines of cases from this court and also from the appeals court, there's a whole line of Massachusetts cases under Article 12 that hold that comment cannot be made on a defendant's pre-arrest, pre-Miranda silence. And those are Thompson, Nickerson, and Benesh. And also in the Grenadier case, the court's reasoning was based on the fact that the questions were not designed to draw meaning from the silence, but to elicit a response to an inconsistent statement, and that's not the situation here. Nor can the defendant's nonverbal conduct be admitted as evidence of consciousness of guilt. These nonverbal responses were testimonial. Other cases have held that a defendant's hanging his head, biting his lips, staring at the floor have all been held as inadmissible for proving consciousness of guilt. And the nonverbal conduct here is about the same as those, if not stranger. Nonverbal conduct indicates what a person is thinking, and I guess evidence, the most important evidence that this is testimonial is the very fact that the Commonwealth put forward the nonverbal conduct for proof of consciousness of guilt.
And that instruction was given.
And that instruction was given, and it was objected to. It was, and the entire that.
And what was the reference? I mean, the instruction sometimes if somebody's fleed, says you can think about fleeing. I mean, what was the actual instruction in terms of this?
The actual instruction was in terms of this. You can consider the conduct evidence for consciousness of guilt. And then the objection was objection to the consciousness of guilt instruction.
With regard to this incident, or with regard to the entirety of his conduct on Saturday and Sunday?
I'm not so sure that was actually consciousness of guilt, really. That was, I'm thinking more that this really is consciousness of guilt. After the questioning, he has this bizarre reaction. And I'm not sure the objection is particularly specific.
But the judge used the word, you can look at his conduct?
Yeah, I've actually got that if you want me to look at it. The judge says, you may consider whether the defendant's behavior on December 12th, 2007 reflected a consciousness of guilt by him.
And that's the date of the
And that's the date of the arrest, yeah. The motion for the required finding. The Commonwealth argues that these errors are all harmless beyond a reasonable doubt due to the overwhelming evidence of guilt, and I would just suggest that there was really very little evidence of guilt here. There's extremely strange behavior on his part. There's handler DNA on the rope and on one of the daughter's necks. He lived in the house. That's not that unusual. And that's about all there was in terms of...
For the neck, it wasn't just, it was right at the location.
Right. But it could have been on the rope, and it was his rope. That's just about the entirety of the
Weren't there some partial fingerprints on some tape?
I don't
or
think anything
something
was
like
really, not anything unusual. I do want to get to the 33E argument, if I may.
that? You'll have to make it brief.
I'll make
if
it
you may.
brief. In the alternative, I filed a motion for to put before this court his medical records. He had inpatient mental health admission. He was diagnosed as major depression, psychotic, delusional. He was on Seroquel. He was found incompetent to stand trial once. I didn't introduce those into the Superior Court because I thought this is really only to be introduced for the 33E argument if you want them. Otherwise, I think there's plenty in the record, plenty of evidence that he was acting not in a normal capacity.
But you're not making the argument here of ineffective assistance.
No. I think the case cited by the Commonwealth is Whitaker, which came after the Colleran case, and came actually after I filed my brief. But in that case. Was insufficient evidence of an actual serious mental illness because the person really just had post-traumatic stress disorder with attention deficit syndrome. And I think in this case that it truly is major depression, psychosis, delusional, suicidal. And if you'd like those records, I'm happy to supply them.
Thank you.
Thank you.
Good morning. May it please the court. I'm Jane Montori, an assistant district attorney from Hampden County, representing the Commonwealth in this matter. I was also co-counsel at the trial of this case.
Ms. Montori, this has nothing to do with the appeal, but was there any evidence as to motive or?
The bedroom in which the mother and the 9-year-old child was found was in complete disarray. It was obvious there had been a struggle. There was a broken window. The telephone had been ripped out of the wall. The room was a mess. There was no direct evidence, but it was clear it was a domestic dispute from that evidence and the way in which Marilyn was murdered.
Didn't he make a statement to police?
He told the police before they knew what had happened. At the time, in the early morning hours of Monday, December 10th, he was seen outside the apartments. He wasn't dressed appropriately for December weather, and the police asked him why he was outside with no coat on, and I'm not even sure he had shoes on at that point. And he said that he had fought with his wife. They had gone to church, they had had a fight, and she threw him out. It was clear that they did have a fight. And while we're on the subject, the fact that he told the police that they had gone to church was a lie, and that was consciousness of guilt evidence as well. And I would suggest that was much more powerful consciousness of guilt evidence than the bizarre behavior that he displayed at the hospital.
Was there evidence of forced entry into this apartment?
There was not. There was no evidence of forced entry. Sergeant Rowland, who was the supervisor of the crime scene, examined both the front and back door extensively and saw no sign of forced entry. He noted that there was electronic equipment in the apartment, which if someone was intending to rob the family, that would have been taken. Marilyn had a lot of jewelry on her that was recovered at the autopsy, including her watch. Her purse was hanging on the bedroom closet door in which she was found, and it had money in it. So that there was no indication whatsoever that this was that this had been a robbery.
And with respect to we want to talk to you about what happened, an incident on Pearl Street and that reaction. You say that's not a problem at all because?
First of all, because the defendant wasn't in custody. He was in the hospital. He voluntarily went with Detective Sierra down to the conference room. That they never expressed to him that he was a suspect. In fact, the statement that was made to him was wholly innocuous. They didn't even tell him they were interested in his address, 94 Pearl Street.
Was there any evidence at that time that he was aware that there had been a murder? I mean, had he been told that there was a murder?
No.
Or that they were dead?
No.
So no one had even said that your family was found dead?
The first words, other than when Detective Sierra went to his room and asked if he would come to the conference room with him, the first words that were spoken were, "We would like to talk to you about something that happened on Pearl Street." So he was not in custody. That was the only statement made to him, so there was no form of aggressive questioning, and he could have returned to his hospital room.
I mean, if he were in custody, put aside that argument, if he were in custody, wouldn't that statement be designed by the police to elicit at least a recognition that he knew something that he wasn't supposed to have known?
I don't believe so. I believe and there are cases that show that such statements are merely introductory remarks to explain why they're there. They're not, I would suggest that was a benign statement, not designed to elicit an incriminating response. So in this case, there was no custody, there was no interrogation, and the Commonwealth position was and is that his physical behavior was not the sort of communication that the Fifth Amendment protects. And I think that the case of Pennsylvania versus Muniz is instructive in this regard, drawing a distinction between a physical reaction such as this and communication or testimony where a suspect or a defendant communicates his thinking or his state of mind or something of that nature, where in this case they made the statement, he started rocking back and forth, he tried to, they calmed him down, he started again, he tried to put his fist in his mouth, he was banging his head on the table, he put his hand to his throat and was applying pressure. At that point, they brought him to the ground for his own safety, but it was not a custodial situation. And
did they say what they thought was happening to him in the hospital? I mean, did they think that he was experiencing a seizure, or what was going on?
They had no idea. They just, the judge didn't permit Detective Sierra to testify, but during the motion in limine on the first day of motion hearings, the prosecutor indicated that according to the detective, he had never seen such bizarre behavior. But that did not come into evidence. That was not before the jury.
Was there a motion to suppress?
There was not.
So this came in purely at trial?
This came in purely at trial. The Commonwealth filed a motion in limine, and the judge allowed the motion. After Detective Sierra's...
Or allowed it over objection of defense counsel or not?
Yes. And after Detective Sierra's direct testimony, defense counsel objected again, moved to strike the testimony, saying that this was custodial interrogation. When that was denied, he moved for a mistrial. He again, at the conclusion of Detective Sierra's testimony, moved to strike it again, and that was denied. I will note that for the court that at no time did defense counsel raise the issue of the use of the defendant's silence as a ground for this objection. It was purely that this was custodial interrogation and that they should have provided Miranda warnings. And
Let me ask you along those lines. Let's put aside this case and take a different circumstance in which a person is in custody, is not given Miranda, and the person asks a question about, tell me about the fact that we found your spouse and your family killed, and then he reacts in this way. Assuming there were a Miranda violation, are you disputing that his conduct would not be admissible?
if he reacted in this way, again, I would say that this is not communication that's protected by the Fifth Amendment. This is distinguished from silence, where there was no reaction or no response. In this case, it was a physical reaction. It was, I would say, akin to slurring speech or inability to walk a straight line, maybe crying, or something along those terms, where it's not, there's no indication of what the person's thinking is. And that's true in this case. And I will note, too, that the defense used, I'm sorry.
Unlike walking a straight line or not able to, this is being used because it's being used as a response to the statement, isn't it?
Yes, but a
And
defendant...
indicating his consciousness of guilt.
That's
I mean,
what.
it has
Well,
to
the
come-
Commonwealth also argued it showed he knew what was inside the apartment, so it was used for his knowledge of what he had done and his consciousness of guilt. But someone crying when confronted with the police is not communication, but that could also be argued as consciousness of guilt. And I would suggest that's a similar circumstance
I guess
to this.
that's my question, I guess. Let's assume there were a Miranda violation. Again, I'm not asking you with regard to this case. And let's assume that, and the person just breaks down and cries. And the Commonwealth wants to argue that his crying demonstrates consciousness of guilt, that he recognized his blameworthiness for it and cried. Is it your view that that would be admissible even though he was in custody and Miranda was violated?
Yes, and the Commonwealth in its brief cites a New York case where that exact circumstance occurred and it was admitted.
So your view is that
Because, again, it's
Miranda,
not-
if violated, and I know you say it's not for two reasons here, but if it were violated, you say Miranda only bars statements, it does not bar conduct.
It bars, it's a fine line, and in some cases, some conduct which may be akin to silence, where there's no response whatsoever, I would suggest that that would not be admissible. But here, there was a response, and it was a physical response. It was a series of physical gestures or actions, which is not, did not convey information, did not assert facts. And in fact, the defense used this conduct as well as the defendant's conduct during that Saturday night and into Sunday night when he was outside the apartments to argue that because of his bizarre behavior, the police accused him of this and then compiled their evidence
Yes, I'm a little
to
confused.
support that.
I understand that the argument, I don't want to belabor it, but if it's communicative, and you're suggesting that it is not,
This is not. I mean,
but if you're arguing really that it's non-custodial, not subject to Miranda and response to an innocuous question, right? But you're really saying that you want what he's communicating, although you're saying it's not communicative, to be before the jury. So I'm a little confused. Because you do want the communication to be before the jury. He's
Well, it's an
communicating his
inference that
consciousness
could
of
be
guilt.
drawn. It's not as though the defendant were asked, are you drunk, and answered yes. That would not come in these if there was custodial interrogation. But the Commonwealth asked the jury to draw an inference from this behavior, just as in other situations, such as not being able to walk a straight line, or having bloodshot eyes. The Commonwealth asked the jury to infer that the person had been drinking.
Here they're asked to infer that the person in response to the question knew that there had been a murder, and his violent response to it was a reaction of his awareness, at least of his awareness, when at that point he's indicated nothing about being there or a murder. That's what you're asking.
Yes.
So in fact,
But there was other behavior, there was other
context,
evidence that showed that he knew what was in the apartment. So even if the court were to find that this should not have been admitted, it was cumulative of the evidence elicited from the neighbor, Sumaya Yusuf, who saw the defendant outside his apartment door, kind of fishing in his pockets, but not really looking for his keys. And not going in or trying the doorknob, the front doorknob of his apartment. He did try the back, but it was locked. So in that sense, and the Commonwealth used that evidence to argue that he knew what was inside. He knew what he had done. So this evidence in that regard would be cumulative of that.
And am I correct that when the police actually entered on that Wednesday, the door was unlocked?
The front door was unlocked.
So
Yes. But no one had tried it. No one none of the police officers who responded in the early morning hours of the 10th had tried the door. And the other reason that if the court were to find that this should not have been admitted, it was harmless error, was because there was overwhelming evidence that he committed these murders. Again, there was strong evidence that there had been a fight in that bedroom. He slit his wife's throat, and he bashed her in the head with a blunt object. The medical examiner testified that either of those injuries were fatal. He bound her hands and then used the rope to also bind her legs. He had a gag in her mouth. He put a plastic bag over her head. He brought her into the closet and buried her under there was a rug, there were some clothing, there were 3 plastic garbage bags filled with items. 2 of them had bedding in it. The bed that was in that room where the 9-year-old was found, the mattress on the other side of where the child was found lying, there was a huge blood saturation stain that matched the blood saturation stain of a sheet that was found in one of those plastic bags that was piled upon his wife in the closet. The child, all the 3 victims were he had attempted to conceal them. His wife was in the closet. The 9-year-old who was on the bed was covered in a duffel bag filled with clothing and other items. His DNA was found on the manual strangulation marks on her neck, as well as the rope bindings that bound her wrists. And Sergeant Rowland, I believe it was, testified that the rope that bound her wrists looked similar to the rope that bound his wife. It was the state of decomposition of these bodies didn't permit a lot of DNA from being recovered because they had tried to recover DNA from the rope that bound Marilyn's wrists, but because of her state of decomposition, the female DNA just overwhelmed everything. They were probably dead for four days before they were found. And the 6-year-old child was also found in a closet of another bedroom, again hidden under a comforter and perhaps other items. There was evidence that the defendant had tried to clean the apartment, and all of this, the way these people were killed, the attempts to conceal the bodies, the cleaning up, the flipping of the mattresses, all of that took time. So whoever did this, the defendant, knew that no one else was going to come into that apartment, that there was no other resident who was going to come in and come upon him. So that also eliminated a third-party culprit. And as to the unless the court has any questions on either deliberate premeditation, I would suggest that, especially as to Marilyn, that certainly was proved, as well as extreme atrocity and cruelty. And the children, that there was medical examiner's testimony that it took them 3 to 5 minutes to lose consciousness and 8 to 12 minutes to die. The youngest child, the 6-year-old, had a pair of pantyhose stuffed down her throat, which would have taken some time, again, deliberate premeditation and extreme atrocity or cruelty. As to the 33E argument, the Commonwealth has never seen any medical records to indicate that this defendant had any kind of mental illness. Although he was cold and the officer suspected he was suffering from hypothermia on the night or the early morning hours of December the 10th when they found him outside the apartment, he was lucid. He was able to answer their questions. He was able to answer the questions of the ambulance personnel who took him to the hospital. There were some medication bottles found in the bedroom, but there was no evidence, and the Commonwealth to this day has never seen any evidence that he suffered from a mental illness. And I would suggest that the way in which these crimes were committed certainly shows that these convictions should stand.
Thank you, counsel.
Thank you.